This program is brought to you by Emory University.
Good morning, everybody. My name is Ivana Moles, and we're here to welcome Anthony Michael Kries today. He's presenting his paper entitled Unhinging Same-Sex Marriage from the Constitutional Canon. Just wanted to alert you to next week's presentation. We have a visiting scholar, Wendy Hesford, coming in from Ohio State University, and she's presenting on child soldiers as human rights subjects. So
when
be
is
sure
that?
to come back for that. It's Wednesday at 2:30 p.m.
Wednesday.
Also next week, we have a workshop, the last in the FLT at 30 series on labor and employment. That's Friday starting at 3 p.m. right here, and a dinner following at the Silver Bell Pavilion at Emory Conference Center, where we will honor the last 30 years of the FLT project and celebrate what is to come, too. The workshop will continue on Saturday all day. So be sure to register for that. And if you need more details about it, please catch me after the program. So without further ado, I'll turn it over to Anthony.
All right. So first of all, I want to thank Professor Feynman for having me here at Emory. I had a really tremendous few months here, and I got a lot of really great feedback on this project and some others, particularly from Mary Duziak and Professor Perry, Tim Holbrook. There was a great faculty roundtable on the Windsor decision, which just informed my views on things tremendously and was a great help. And Outlaw and the Emory Law Journal have also been very good to me, so lots of thanks to go around. So let's start off with Windsor. So enacted in 1996, Defense of Marriage Act amended the Federal Dictionary Act to define marriage and spouse to explicitly exclude same-sex couples from basically 1,000 statutes and regulations. Now, when it was enacted, DOMA had no real practical effect. No jurisdictions at the time in '96 recognized same-sex marriage, but once Massachusetts did so in 2004, DOMA had the effect of barring lawfully married same-sex couples from a wide array of federal benefits, including Social Security, housing, taxation, copyright, Veterans Affairs, and a whole slew of other things. And then last summer, the Supreme Court was called upon to rule on DOMA's constitutionality. The case, U.S. v. Windsor, held that DOMA violated the equal protection guarantees incorporated in the Fifth Amendment. Writing for the court, Justice Kennedy held upon, quote-unquote, careful consideration that DOMA had the purpose and effect of imposing inequality on married same-sex couples, thereby rendering DOMA constitutionally deficient. Now, some commentators had assumed and projected that the court might render a decision on purely federalism grounds or punt on standing. The court obviously didn't do that. And Justice Kennedy certainly couched the Windsor holding in a hybrid of substantive due process, equal protection, and federalism. But the hybrid opinion did not cleanly articulate what level of scrutiny that applied. So, in particular, I want to focus on the substantive due process component of the decision. So now, under the traditional formulation, as we all know, of substantive due process, fundamental rights and liberties, those rights and liberties that are deeply rooted in national history, tradition, and the conscience of the American people, those rights, when impinged upon, demand strict scrutiny from the courts. From other substantive due process guarantees that are not fundamental rights, courts apply the highly deferential rational basis. Now, Windsor suggested that the scrutiny applied was much more exacting than traditional rational basis, and indeed courts have recognized this. I think most notably the Ninth Circuit Court of Appeals in SmithKline Beecham versus Abbott Labs, which was a juror disqualification case on the basis of sexual orientation, made it very clear that Windsor applied heightened scrutiny, and applied heightened scrutiny, citing Windsor in that particular case. But Justice Kennedy's failure to cleanly spell out the rationale underpinning the court's opinion, particularly how same-sex marriage fits within American history and tradition, opened up the majority to significant rebuke from 3 of the 4 dissenting justices, the Chief Justice being the one who really didn't latch on to the history and tradition component. Because the majority opinion did in fact suggest that heightened scrutiny applied, but did really little more than flirt with the idea that the marriage recognition that the challengers to DOMA sought was a fundamental right. So at the time that DOMA, the Windsor decision was decided, there were 12 states that recognized same-sex marriage. California became the 13th once the court dispensed of the Perry case. But at the end of the day, we had a handful of states that recognized same-sex marriage. So let's take a look at the dissents. So Justice Scalia, ever witty and biting in his tone, says, majority never utters the dread words substantive due process, perhaps sensing the disrepute into which that doctrine has fallen, but that is what those statements mean. Yet, the opinion does not argue that same-sex marriage is deeply rooted in this nation's history and tradition, a claim that would, of course, be quite absurd. Justice Alito wasn't much kinder. He said, first of all, that this was not a difficult question of constitutional law, and he said, he articulated an idea that constitutional rights, particularly fundamental rights, should be constructed at a granular, narrow level. It is beyond dispute that the right to same-sex marriage is not deeply rooted in this nation's history and tradition. In this country, no state permitted same-sex marriage until the Massachusetts Supreme Judicial Court held in 2003 that limiting marriage to opposite-sex couples violated the state constitution, nor is it the right to same-sex marriage deeply rooted in the traditions of other nations. No country allowed same-sex couples to marry until the Netherlands did so in 2000. This rationale is not new. They didn't create this out of thin air, this idea that there's no history or tradition to same-sex marriage and therefore it is undeserving of constitutional protections. We've seen this in a number of state cases. The cases in the courts of last resort in District of Columbia, Maryland, New Jersey, New York, and Washington all denied claims from same-sex couples suing for marriage licenses. They all rejected the idea that this was a fundamental right, and they all did so basically saying there's no history and tradition of same-sex marriage, and therefore we're not going to recognize it as a fundamental right. Notably, every single one of these decisions was overturned by subsequent legislation, with the exception of New Jersey. In Lewis v. Harris, the Lewis decision was reversed by litigation filed after the Windsor decision in October 2013. But the bottom line here is that this construction that we saw in the state courts, the construction of same-sex marriage as a fundamental right that we saw in the Windsor dissents from Justice Scalia and Justice Alito are wrong. Both dissents and these prior state cases improperly frame the historical question by structuring the analysis from the narrowest possible level of abstraction. So the question cannot be, does a constitutional challenge from same-sex couples asserting a right to marry create a new fundamental right, a right to same-sex marriage, as Justice Alito said numerous times? The question must be, can the government's prohibition of same-sex couples' access to a singular fundamental right, the freedom to marry or not to marry, withstand heightened judicial scrutiny given the deeply rooted tradition of marriage in the national fabric? Now, time and again, the Supreme Court has reiterated and reinforced this bedrock principle that the freedom to marry or not to marry is a fundamental right. All these cases say it in one way, shape, or another. However, when it has significantly extended that right, it has never relied upon the type of analysis that the state courts or the dissenting justices have proffered. And so I want to take the time to highlight how this is an improper formulation and application of substantive due process, and specifically do so through the lens of prisoner marriage and interracial marriage. So, Turner v. Safely, the court rejected the long-standing and near-nationally uniform history of denying prisoners the right to marry. So in Turner, Missouri prisoners successfully challenged a regulation that prohibited inmates from marrying other inmates or civilians unless the prison superintendent had given his permission. Not only did he need to be given, the prisoner need to be given permission by the superintendent, but the superintendent had to find that there was compelling reasons to justify the marriage. And Missouri's regulations were pretty on par with, for the course with most prisons at the time. Indeed, most state prison regulations provided very broad discretion to prison administrators to permit or deny marriages involving an inmate. So we see the typical marriage regulation before Turner, broad discretion, individual case examination, but it's a very invasive inquiry. Why do they want to get married? Was there a relationship before they were, one of the individuals was in prison? What are the plans post-detention? Financial assets, public interest, all sorts of things that are very invasive, and there's no appeal process beyond the prison walls. Courts regularly rejected challenges to these prisoner regulations. In the years preceding Turner, they regularly upheld the regulations that Turner in fact held were unconstitutional, and often without any serious consideration. It was not until the early 1980s, only a few short years before Turner, that courts actually gave a hard look to these constitutional challenges. Before that time, particularly in the 60s and 70s when these cases began to percolate, courts basically rubber-stamped the prison officials' policies. There was just no discussion about it. And they were dispensed with pretty easily. Yet, this history of systematically denying prisoners' rights was not a part of the Turner Court's analysis. The court did not ask whether the practice of inmate marital rights was embedded in the nation's fabric. It didn't ask if it was embedded in our history. Rather, the court just framed the issue as the right to marry. So like Windsor, Turner didn't employ strict scrutiny. They didn't have to. The court sidestepped the strict scrutiny analysis, holding that the marriage regulation was not reasonably related to a legitimate prison interest. But more importantly, again, the court never said that the inmate's right to marry required some separate analysis as to whether they were seeking a new right to prisoner marriage. That was never a part of the analysis. So the court properly used the similarities or differences between marriages between two civilians and marriages to which a non-civilian inmate was a party to weigh the validity of the rationale proffered by the government for restricting the fundamental right to marry, not the nature of the right asserted itself. And I think that's important. But it also begs the question, what if the court had to do this fundamental rights analysis? What if they had to talk about history and tradition, and they did so in the way that Justices Alito and Scalia would have us do? 5 states generally allowed prisoners to marry 10 years prior to the Turner decision. California and Pennsylvania were the only 2 where that right was statutory. In Oklahoma, Tennessee, and Connecticut, it was a prison policy that generally allowed, and in Connecticut and Oklahoma, it wasn't written. So in Tennessee, it was a Bureau of Prisons regulation that basically said, we're going to generally approve these requests. So we had 5 states, in one way, shape, form, or another, said we will generally allow prisoners to marry, and only 2 of them codified it in state law. I think that really weighs against the idea that had the court engaged in the type of analysis that Justice Alito and Justice Scalia and some of these state courts have put forward, there's no way that you could say that there is any tradition or history of allowing prisoners to marry. You would have to simply reject it. Loving. So Loving versus Virginia also highlights the problematic posture of Justice Scalia and Alito's framework, probably more so, and certainly more so than Turner. Loving held, of course, that anti-miscegenation laws violated both equal protection and due process clauses of the 14th Amendment. Yet, interracial marriage was long disfavored by society and prohibited by law since the nation's founding. During the early 17th century, for example, Virginia enforced unwritten miscegenation prohibitions by public whippings and church penance. By 1691, Virginia actually codified this in statutory law. Virginia's early prescription was not alone. Delaware, Massachusetts, North Carolina also joined Virginia and enacted anti-miscegenation laws prior to 1725. Only a handful of states never enacted anti-miscegenation laws. And I don't even honestly count Hawaii and Alaska because they came in the Union so late. So if you look at the 48 continental states, only a handful never prohibited interracial marriages. But Loving also highlights another problem, which is that not only were anti-miscegenation laws a long-standing part of America's history back to the colonial period, but it was commonplace more or less 20 years before Loving was decided. Indeed, until the California Supreme Court in 1948 ruled that California's anti-miscegenation laws violated the 14th Amendment, no court had ever held that a miscegenation statute violated equal protection principles. 3 years after that ruling, and 16 years before Loving, 29 states prohibited interracial marriages, including 6 states that banned interracial marriage by state constitutional amendment. But in the southern states? Yeah. So the red states are statutory bans, and the orange are state constitutional bans. And those states are the ones that existed at the time that Loving was decided.
So Georgia was a relatively progressive state, my God.
I'm going to get there in a second. Actually, I'll do that right now. Georgia. So Georgia's an interesting case. And if you look at there's some really great articles in the old Harvard Law Reviews, the old Yale Law Journals, the old, before it was Duke Law Journal, I think it was Duke Law Forum. That came out at the time, and none of them, they all had like these really great charts that probably took them forever to do on typing by hand, but they were beautiful charts, and all of them left Georgia out. So Georgia's an interesting one. Georgia never had like its neighbors. Georgia never had a provision in its state constitution that explicitly said interracial marriage shall be banned, or any iteration of that. Georgia did this thing where they decided, we're going to put this seemingly innocuous thing in our constitution and then interpret it as banning interracial marriage forever. And it's Article 1, Section 1, Clause 25. The social status of a citizen shall never be subject of legislation. And social status, the Georgia Supreme Court has interpreted twice. Prior to, one was in the 1860s and one was in the 1890s, interpreted this provision to mandate that interracial marriages be constitutionally banned. Interesting fact, it's still in our Constitution.
Well, I'm sorry, I don't see the relationship between that statement and that interpretation.
I don't either. But that's what the Georgia Supreme Court had consistently said it actually meant. There was some debate as well that it actually also mandated segregation more broadly, and that it was the intent to prevent any type of civil rights legislation at all. But that's the court's interpretation, and the court has never interpreted it otherwise since. So
in other words, the idea is that the lawmakers, the legislators, could not authorize same-sex marriage because that would be legislating.
It would be
the social status of us.
They couldn't authorize interracial marriage.
I mean.
Yeah.
Yeah.
But that the idea is that they could never repeal the statutory ban on interracial marriages because it would be
legislating.
It would be a social status. It would be
interesting.
Promoting equality, basically. But I think this is a good place to stop real quick and look at how these different things pair up. So at the time, 10 years prior to the relevant Supreme Court decision, so 10 years prior to Loving, 27 states permitted interracial marriages. Only 2 permitted statutorily prisoners to marry, and 13 provided at some point a right to same-sex marriage. And I'm including California in that. But I also think that the idea of interracial marriage having, again, it had a long presence in the American marketplace of ideas, but it was emphatically and aggressively rejected throughout the nation's history. And unlike what I would consider a non-tradition of inmate rights, I don't think there was anyone out to really block inmates from getting married. This was really a very hostile tradition against marriages between mixed-race couples. But the idea, I also want to highlight that not only was there no history or tradition of this, but certainly this was not some part of an American consciousness that suddenly came about in the 50s and 60s that interracial marriage was a fundamental right, that somehow there was this national awakening, that this was deeply rooted in our national public conscience. Only a few short years in 1959, before the Loving decision in 1967, only 4% of Americans said that they approved of interracial marriages. Right after, a year after Loving, that number creeped up to a whopping 20%. If you compare that to same-sex marriage in similar time frames, there was far greater support for same-sex marriage in 2006, the same time period before the Windsor decision and before the Loving decision in 59. There was far more support for same-sex marriage in 2006 than there was for interracial marriage in 1959. And I think that highlights some of the very steep problems with the analysis that Justice Scalia and Justice Alito have posited in Windsor, and these other courts have done so on the state level. So, I want to conclude with a number of things that I take away from this. I think first and foremost, the dissenters' analysis really subjects same-sex couples to a subordinate status within the constitutional framework. I think it is a very strange thing that the courts, which are supposed to be the guardians of minority rights and the protectors of individual liberty, don't see fit to use the traditional, historically accurate constitutional analysis for same-sex couples, but rather would like to just create a new analysis for them, because that's just what they see fit. And in doing so, the Windsor dissenters walled off same-sex couples and their families, too, from what the definition of family is. In order to get to that place where they're going to create this subordinate, inferior constitutional inquiry, the only way they can get there is if they basically say, these people and their families are just different. There's something fundamentally different about them. And I reject that as being untrue. I think also, though, the dissents really highlight for me a broader problem. Judges are not historians. And I think judges should be very cautious when they use history, because it's very easy to bend history as you see fit and to make it what you want to make it. And Justice Stevens has been very critical of judges doing this in the Heller decision. So, in the Second Amendment case or a Second Amendment context, this can happen. It can happen in the 14th Amendment context. It can happen in a whole slew of other contexts. I think we need to be very cautious about the way judges use history to support their opinions. But I also think, as well, it should cause us some pause, particularly on the tradition aspect. Tradition has been justified to do a lot of awful things. And, of course, I think we are very proud of many of the traditions we have in this country, and certainly there are many great traditions that we have. But that does not mean that just because it's a tradition that we should embrace it without questioning whether this tradition is worth having or not. and do these traditions hurt other people? Certainly, this is a scenario where we use tradition that extends or could harm far more people than just the LGBT community. Women, racial minorities, religious minorities, there are a large amount of people who I think could be very subject, or they're vulnerable to this kind of analysis. And I think that there's a lot of truth to the idea that one of the most dangerous phrases that anyone can utter is that we've just always done it this way. And I think that that's particularly problematic when judges adopt that view and just say, we've always done it that way. Because there's a reason why we have the Constitution, to prevent just always doing the same thing and injuring people in the process. So I want to, again, thank you very much for having me. It's been a really pleasure. It's been a pleasure to be here and to give this talk to you all, and thank you. So if y'all have any questions.
Well, I think for the questions, if we could ask you guys to come around here, because there's a mic actually here, so we could capture your questions as well. Or we could take a break for coffee, because I think it's ready now.
I can do whatever y'all want. So.
Well, I'm ready to engage you if we're not going to break for coffee.
Okay. We can do that individually.
Yeah. Anthony, the quotations from the dissenting opinions with which you began, Scalia's quote and Alito's quote, presuppose that the majority opinion is a substantive, is at least in part, a substantive due process opinion of the sort that would make inquiry into whether something is deeply rooted in the history, presuppose that. But that seems to me a very mistaken presupposition. I don't know why Kennedy didn't choose to reply to it, but when you look at the cases, the contraception cases, Griswold versus Connecticut in 65, Eisenstadt versus Baird in 71 or 72, abortion, Lawrence, you look at these are all widely understood to be substantive due process cases, but none of them are cases that involve an analysis of whether something is deeply rooted in the history or traditions of the American people. So clearly there's more than one kind of analysis that proceeds under the name substantive due process. But more fundamentally now I'm not speaking so much in criticism of the dissents, but among us here, it's very clear that the doctrine of substantive due process is historically unwarranted. I mean, the idea that the due process clause warrants that so why not understand, and what I'm saying I'm sure you're familiar with because I've sent you some of this, but there are two possibilities in Windsor. I mean, Kennedy is clearly making comments about the imposition of inequality on same-sex marriage, demeaning, can't do that kind of thing. So he could be saying one of two things. He could be saying that people whose sexual orientation is same-sex are themselves inferior in some way. And that would be a cardinal equal protection problem, a demeaning, dehumanizing view of individuals. Or the idea could be that same-sex sexual intimacy is morally offensive, which is not a comment about the moral status of those who engage in it, any more than a comment about burglary is a comment about the moral status of whether the people who engage in it are truly fully human. So let's assume that with respect to same-sex marriage, that most of the opposition to it is based on the view that there's something morally problematic about same-sex sexual intimacy. So in that case, it's less a case about marriage and the fundamental status of marriage in our history, right, than it is about whether the state gets to say that this kind of sexual intimacy is morally problematic.
Right.
It doesn't get to say that if it's saying it on the basis of the Bible, right? We can all agree about that. So if it's not saying it on the basis of the Bible, it's saying on the basis of what I call some sectarian moral view, like that of the U.S. Conference of Catholic Bishops on inherently non-procreative sexual conduct, then the problem is not, this is not a right to marriage case, because you're going to run into Robbie George and the others who say that marriage is a natural kind, and everything you've said is irrelevant because marriage involves a man and a woman, and then you've got all those cases you cite accepted that understanding of marriage, but you're doing something else. So why not move it away from this being about marriage to being about the state declaring that a particular kind of conduct is immoral or morally problematic, which then the argument is the state cannot do, because its only basis for doing that is either religious, and that's ruled out, or a sectarian moral view, which the court effectively ruled out in Lawrence and the contraception cases and various other cases.
So I would say a couple things. One, I think the presupposition on the dissenters' path, I don't know how many times, I used to know, how many times Justice Kennedy reiterated dignity. And I think, I don't know if you've read it, but Bruce Ackerman had a really great New York Times op-ed about this idea of a constitutional right to dignity. And I don't think Justice Kennedy would go that far to say that. But I certainly think that's where that presupposition is coming from. It's coming from that idea that this is really about dignity. The other thing I would say is...
I don't understand what you're just... Can you elaborate what you're saying?
I think the reason why they presume that this really was a substantive due process decision in its flavor, or if nothing else, heading that way in the next decision, is because this idea of dignity was so pervasive that that's where they're getting this from.
Well, why do they associate that with substantive due process?
Well, I think that's the best thing they got going for them. Because truthfully, I don't think they have a leg to stand on in their dissents anymore, particularly after Lawrence. Justice Scalia was very clear about that in his own dissent in Lawrence. And so I think that the best way to attack it is something that, is substantive due process. It is, obviously, I think it is clearly something that is rejected by a large amount of people in the legal community, in the academic community. And it's probably their best shot at taking some pot shots at the majority while they can.
So why doesn't the majority simply say, look guys, because they were all guys on the other side, right? Look guys, this is not a substantive due process case. We're not saying that. So everything you said in that regard is beside the point.
I would suggest that that's more about strategy than it is about law. And I think the truth of the matter is, on my perspective, is that Justice Kennedy wanted wiggle room for himself later down the road. That if he wanted to backtrack and say, well, I don't want to reach the question on the state level, I can distinguish what I said in Windsor somehow, so I have enough wiggle room that I can kind of put the, maybe not put the kibosh on it, but slow it down a little bit. It also might have been strategic in order to I think Chief Justice Roberts' opinion made it very clear that he's willing to have some wiggle room too, and flip on the other side once it comes up from on the state level. I think the ambiguity has some strategic value. So yeah, I certainly believe that he could have written an opinion that directly contradicted every single statement that the dissenting justices had. But I also don't think that's in his long-term interest. Certainly not, I don't think, in same-sex couples' long-term interest. And I also think that Justice Kennedy just likes flowery opinions. I think his opinion in Lawrence, finding yourself in the cosmos, or however he phrased it.
That was the Planned Parenthood.
Yeah.
Casey. Yeah.
So I think that part of it's also just style. I wish I was a fly on the wall and had the perfect answer, but I think part of it's style, part of it's strategy, and part of it's just the dissenting justices.
Part of it is not discerning things as deeply as you would like them to.
Yeah, absolutely. Any questions? No, well,
Well,
okay, yeah.
I mean, what's the question? I was interested in hearing more about how you see the relationship of identity to fundamental rights. It seems like on one hand, you're arguing that fundamental rights should be vacated of any kind of identitarian politics. There's something like the freedom of the right to marry is something that applies to all, regardless of race or orientation or minority status. But you also are making the argument for those same minority rights, right? Saying there has been historic disenfranchisement, there has been a history of tradition which is actually negatively impacting on minority rights. So I just wonder how you reconcile those two, I think, quite different strategic moves that you're making.
Yeah, not easily. I think on one hand, I certainly am skeptical of the whole history and tradition component of any legal analysis generally. I just, that alone is not a reason to come out one way or the other on it.
But I think you
right?
yourself are arguing that there has been a history of marginalization
Right.
of same-sex couples or of gay identities, right?
Right.
Which is something that needs to be combated or needs to be reconciled, or needs to be ameliorated.
Right. I'm gonna have to rephrase. So,
So you're saying on one hand we don't need identity, right? That freedom to marry is a fundamental right that should be accessible to all, regardless of identity, politics, or identity categories. But on the other hand, you're saying here's minority identity, which has been historically discriminated against. This is a cause of concern. We need to address that somehow. Right? So you're saying on one hand it doesn't matter, on the other hand identity is critical.
this is why I think I approach it this way, and it's something that I'll probably need to chew on more because you've articulated it in a way that I've never been pushed back on. So, first impression response. But I think on one hand, there's an innate desire to embrace the identity and to say, we're just like any other minority group, and there's a recognition that we've suffered as a group. I think that's also necessary to a certain extent to draw a delineation between. So I often hear from the Robbie George crowd about what's next, and it's always the polygamy is the next one, and I haven't really thought about that yet because I'm still fighting my own battles right now, but in my mind, the thing I can always say is, well, I don't know about that yet, but what I do know is that this is an identity and it's innate and it fits in with all the other kind of traditional legal analyses that we do, Caroline products, we're discrete, insular minority. And so there's a struggle, I think, between trying to fit in that and to hedge against, the parade of horribles discussion that I don't particularly enjoy getting into. But also at the same time saying that despite these differences, there are no, we're just like everyone else. And I do have a hard time grappling with these different, the different tension. It'll be something that'll have to.
But it seems like maybe and I appreciate the strategy that you're using. Right? It seems like you're grasping for this gold ring of strict scrutiny, and whether you can get to it through fundamental rights, whether you can get to it through identity categories and historic marginalization, you're kind of trying to do both of those things at the same time. You're making this like an argument for strict scrutiny, but you're trying to reach it from two very different angles. I think you can say, I'm just like, however I can grab that brass ring, I'm doing my best for. But I think you're actually you're making an oppositional argument to try to get a certain goal.
Yeah.
So just to follow up on that, and that was a vulnerability question. I really appreciate that. So you talk about the distinction between creating a new right, a right to same-sex marriage, a new right, versus the argument that people are being excluded from the singular fundamental right, which is marriage, right? And I think that you can explain Turner and Loving in kind of interesting ways, because Turner is a substantive due process case because it focuses on the institution of marriage. Mm-hmm. So, and that's the focus, that's the institutional focus. And the identity of the individuals is in many ways irrelevant, because it's really about what marriage is. And incidentally, what marriage is, and why I would focus on marriage, is an institution that is heavily subsidized by the state. So when we talk about marriage, we're talking about the state privileging certain individuals and certain relationships. And the question should be why others are excluded from that set of privileges, not from the institution of marriage, which legally it could be understood just as that. Where loving is really about race, and it's more in the discrimination category. And when I teach loving, I don't teach it as a right to marry case, because I think that's an error. But so I totally agree with Stu. And when you got to your list of conclusions and you started to talk about same-sex couples are subordinated, there's a wall against same-sex couples and their children from becoming families, you bring us back to identity again, and back to that whole set of things that really should be irrelevant to the discussion of what the state does through the institution of marriage, and who's being privileged and who's being disadvantaged, and how is that justified. And that's the debate about children. I mean, you see this, it's in there, it's in these cases. It's not articulated clearly, but it's in there, this whole discussion, intuitively they went to this discussion about children have to be raised by heterosexual couples so they learn how to become real men and real women, or whatever that nonsense is. So anyway, I think that's what you're doing. You're taking a vulnerability analysis and applying it to this set of cases, and it really fits really well. So that's exciting.
I know it's, I know from years and years of discussing these issues with the students, that the distinction I'm about to refer to is a distinction that it's hard for many people to wrap their minds around. It's the distinction between a demeaning or dehumanizing view of an LGBT person simply in virtue of the fact that they are LGBT, right? And a view that a particular kind of conduct is immoral. So the official position of the Vatican, and therefore of the United States Conference of Catholic Bishops, is that gays and lesbians are truly fully human. They are all our children, equally beloved of God, entitled to be Pope. If one, if you're a man, one of them gets to that point. But that inherently non-procreative sexual conduct is immoral, which is not a position about same-sex sexual conduct per se. It's a position about all inherently non-procreative sexual conduct, including a married couple's use of contraceptives, which is where the church is, that's mainly played out. So the constitutional analysis, one of the reasons why, my students in the court too, we're so familiar with demeaning, dehumanizing views of gays and lesbians and sexual minorities, that the instinct is just to think that's what's going on here. And it is no doubt going on there in the opposition of a lot of people to same-sex marriage, right?
Right.
But it's not what's going on with respect to very many dominant positions opposing same-sex marriage. What's going on there is, look, we embrace you as our equal brothers and sisters, and you can be Pope. But this conduct, as a species of inherently non-procreative sexual conduct, is, in our judgment, immoral. And that's why we oppose giving the imprimatur of the political community to, what you call same-sex marriage. You see Robbie George would put the marriage in quotes. That's a very different position for purposes of constitutional analysis. Because Martha's right. I mean, Loving versus Virginia there's no way to understand anti-miscegenation legislation except as based on a demeaning, dehumanizing view of people on the basis of race. It's a manifestation of white supremacy. But there is an easy way to understand some opposition to same-sex marriage as not based on a demeaning, dehumanizing view of individuals, but as a judgment about the morality of a certain kind of conduct, inherent, and it's not even specifically gay, sex, right? So that's why the court and students and others seem to have such trouble sorting all of this out, So it seems to me important to emphasize the complexity of the views that are opposed to same-sex marriage, opposed to marriage equality.
I think that, one of the great examples of what you're talking about, I think it was either the Bishop of Spokane, Washington, or Seattle. I think it was Spokane, and Catholic Bishop of Spokane wrote a pastoral letter right before the November referendum, and basically said, what you were saying, we fully recognize our gay and lesbian brothers and sisters are equal. We don't believe that marriage should be anything but this, but we don't condone any other form of discrimination. Right. So those messages have penetrated in very, every once in a while I see them pop up. I think the dominant thing is those aren't the messages that get through. I mean, you get the Bob Barrs of the world talking about hedonism, looking at our boots, and you get the Michael Boggs of Georgia, talking about this is a Christian nation and how can we tolerate sin and the evil of homosexuality. That's the dominant paradigm, and I think it's very hard to disaggregate these different types of messages, particularly when the overwhelmingly dominant and most powerful one is just this is sinful and evil and pure. It's wrong no matter what.
Homophobic.
It is. Yeah, it's homophobia. Pure and simple, and that's what's pushing the legislation. That's what's pushing push the constitutional amendments. That's what's feeding this. It's not this kind pastoral kind of let's just kind of take this in a view that's nuanced and reasoned within that's removed of the homophobia.
I'm forgetting the name of the Yale law professor who's the expert on statutory interpretation.
Bill Eskridge?
Bill Eskridge has a piece, I think, in the Georgia Law Review, in which he focuses on this phenomenon of it's not about you, it's about the conduct. And so there's a lot of very interesting information, and he gets it. He gets it in the piece, the distinction in that Georgia piece.
But the thing is that the distinction is never made really in the dominant conversations. It's just one way or the other. There's very little nuance.
Well, Robert George and that crew, Sheriff Gerges, George, and what's his name, Ryan Anderson. Yeah. They're a major voice in certain elites on this issue, and of course that distinction is fundamental for them.
Right.
So.
And I think the problem with that now, and this, just from what I've seen, is that there is the folks who were incredibly, and still are, I presume, homophobic and just rabidly anti-gay, are now adopting this position because it seems free of animus.
That's right. Exactly.
And so, they've really corrupted that argument from having any, I don't want to,
Which is why it's important to have a powerful argument against that, quote, free of animus argument.
Right.
Right?
Right. I would agree.
But you're going to run into this every time that you're thinking about that, the discrimination being the basis of your argument, a focus on the individuals rather than a focus on the institutions. You're going to run into this because it requires intentional discrimination, animus. It requires all of that because we're focusing on the intents and the actions of individuals, again, rather than how the institution functions and the state's relationship to that institution, what the state's doing through that institution, which is just because it doesn't really matter whether you can do that. Make this distinction between we love the sinner, we hate the sin. It's really irrelevant when we're talking about what marriage does in this society and how the state privileges certain relationships and what's the reason that it does that. And it should have to explain its reasons.
I don't think it's either or. I think the kind of thought and analysis and vulnerability approach and so forth that Martha's engaged in is essential. But it is also important in constitutional argument to have a very powerful argument about the Robbie George type of opposition to marriage equality. And that is not an argument that's vulnerable to equal protection analysis, but it is an argument that's vulnerable to another kind of constitutional analysis.
But I wonder, this sort of neat bracketing of status from conduct, I mean, I must say, I find that offensive as well. I mean, as a gay person, it's not as if I can simply separate those two things. It makes me think that if I mean, and I do appreciate the perspective of it being a deeply held moral belief, and it's a way to engage with people across an aisle, and it's not tarring everyone as homophobes across the ideological divide, and I understand that. But I wonder if it's not also riddled with hypocrisy, and that if that was really the case, wouldn't those folks also be picketing fertility clinics? Right? Aren't there other ways they would be concerned?
They do. Those folks being, yeah, here's my answer to your question, Stu. I mean, the U.S. Conference of Catholic Bishops does have an official position against in vitro, I mean, the whole range, so that's not going to get you very far. They are quite consistent. They've got 1,000 years of figuring out how to be quite consistent about these sexual issues. So that's not the, now that may be true with respect to somebody else.
Yeah, and of course, non-reproductive heterosexual couples would also have to divorce after a certain period if you don't produce children, and therefore
they've got answers. They've got answers to that.
Yeah.
They deal with that. George Gerges. I mean, if you really want to, engage the issue at the level of sophistication on the other side, then what you've got to do is you've got to read George Gerges and Ryan Anderson. See what they say about it, because it's problematic, but it's more sophisticated than you might think, not having read it.
Yeah. It's still
Yeah, I've seen Ryan Anderson in particular do a lot of, or engage in a lot of legislative testimony, and it's eerily effective.
I'm sorry.
It's effective.
Yeah,
it is as effective as the opponents can be.
Right. Which is why you really want to know their script intimately and not just,
Well, thank you.
Thank you.